Welcome everyone to the fourth event in the Andrea Mitchell Center for Democracy's year-long series, Free Speech Battles. The series as a whole is helmed by the amazing and visionary Sigal Ben-Porath, Professor of Education and expert on free speech on campus. And she's assisted by a committee consisting of faculty from across the university, Joe Lowry, Sophia Rosenfeld, Tukufu Zuberi, and me, along with Jeff Green and Matt Roth from the Mitchell Center. I should say, I'm Amy Seppenwall from the Department of Legal Studies and Business Ethics at Wharton. So tonight's event is co-sponsored by the Mitchell Center and the SNF Paideia program, and we're going to be focusing on moral and constitutional questions around boycotts. I'm delighted to be moderating the event and to be in the company of our three formidably smart and thoughtful panelists whom I will introduce in a moment. But even before that, I wanted to begin by saying a few words to motivate some of the issues that we're going to be discussing. So this country, as you all know, has had a glorious and rightly venerated history of protests, some peaceful, some not. So think, for example, of the Boston Tea Party, the Montgomery bus boycotts, the Stonewall riots, Take Back the Night events, Occupy Wall Street, to say nothing of the recent and potentially transformative Black Lives Matter demonstrations. And of course, global protest movements have agitated for necessary social change. Think here of the efforts to dismantle apartheid in South Africa, demonstrations in Tiananmen Square, and more recently, the Arab Spring and Hong Kong demonstrations. Now, protests can be effective for those without formal or realized political power, but they can also have a dark side. And scholars have singled out boycotts in particular as potentially troubling forms of activism, even though many boycotts are justifiable at the end of the day. Scholars in particular have expressed two broad concerns about boycotts. First, many boycotts involve threats to the boycott target's livelihood, and it's wrong, the claim goes, to seek to change a person's conduct through coercion or threats. Second, some scholars claim that boycotts are inconsistent with democracy. Why might that be? Well, because these scholars argue boycotts risk effectuating political change not through the regular channels of democratic deliberation, but instead through coordinated market activity, which has none of the participatory safeguards that the regular channels provide. And the concern about boycotts isn't limited to scholarly commentary. In the last 5 years, dozens of states across the country have passed laws that would exclude individuals or businesses who participate in certain boycotts from government contracts. Most prominent among these are laws that target individuals or businesses that have participated in the movement to boycott, divest from, or sanction Israel for its conduct in the West Bank, or the Bds Movement as it's popularly known. These laws disqualify individuals or businesses that support the BDS movement from receiving government contracts. So boycotts raise moral issues, and they also raise First Amendment issues of two kinds. First, there's the free speech right of the party that boycotts, but there's also perhaps a First Amendment right of the state or its citizens not to support certain boycotts. Perhaps because the boycott's cause is morally problematic, or because the cause conflicts with the settled policy of the state. So we're going to interrogate all of these pieces with our panelists tonight, each of whom is among the leading thinkers on these issues. And so without further ado, I will introduce them. First, we have Genevieve Lakier. Genevieve is an assistant professor of law and the Herbert and Marjorie Freed teaching scholar at the University of Chicago Law School. She has a JD and a PhD in anthropology, and she writes on the First Amendment with a particular focus on economic incursions into free speech doctrine. Next, we have two of my very own colleagues, Brian Berkey. Brian is an assistant professor of legal studies and business ethics at Wharton. He has a PhD in philosophy, and he works on topics as varied as climate ethics, effective altruism, animal ethics, exploitation, and most relevant for us, ethical consumerism and democracy. My other wonderful colleague on the panel tonight is Amanda Sheener. She is also an assistant professor of legal studies and business ethics at Wharton. Amanda has a JD and she is soon to receive a PhD in law. And she's also an exciting voice in First Amendment scholarship, where she seeks to rehabilitate a pro-democracy and pro-equality strand of jurisprudence against the court's recent libertarian turn. I should add that both Amanda and Genevieve have signed on to amicus briefs in cases where individuals have challenged state laws excluding them from state contracts because of their participation in the BDS movement. So our panelists' collective expertise promises to make tonight's conversation exceptionally rich and fruitful, and I could not be more delighted to have them here. Before turning things over to them, let me just offer a few notes as to how we'll be proceeding. I'm going to have each of them speak for a few minutes to offer their overarching thoughts, and I will then ask questions of them, of our panelists, and after that we'll take questions from the audience. So if you have a question, please enter it in the Q&A. I should note that we have with us tonight students from my LGST 221 class. Good evening, students, and students in Professor Rosenfeld's History 133 Free Speech and Censorship course. My students submitted questions to me in advance, and I'm going to pose a couple of them on their behalf. But if you're a student in Professor Rosenfeld's History 133 class, please preface your question with your course number. That is, when you type your question in the Q&A, please include the course number so that we can prioritize you during the Q&A. All right, with that, I'm going to turn things over to Genevieve. You can get us started.
Okay, well, thank you, Amy. Thanks so much for having me. I'm really looking forward to this conversation. You know, I teach in law school, so I'm always talking to other law people, and it's just doctrine, doctrine, doctrine. So it is really nice to have an opportunity to think about the relationship between the philosophical, the ethical, and the doctrinal. But betraying where I come from, I'm just going to start off by describing briefly why it is that I think that in this case, the question of the constitutionality of the laws that Amy just referred to, these laws that impose impose sanctions, restrict the rights to receive state contracts or state investments to participants in boycotts, and particularly the BDS, or the Boycott, Divest, and Sanction boycott against Israel, why these laws are clearly unconstitutional. Doctrinally, you know, the First Amendment is, many questions raised in First Amendment cases are very difficult ones. I think this case actually presents the unusual case of an easy question. And this is because for many decades now, and without much ambiguity, courts have recognized that what they call political boycotts, that is to say boycotts that are enacted in an attempt to promote political or social or economic change, are fully protected by the First Amendment. And what that means generally is that the government may punish this kind of collective action only in the most extraordinary circumstances. Now, this is in sharp contrast to a category that the court has called economic boycotts, which is defined more or less as boycotts that are intended to further anti-competitive ends, that is to restrict competition in the marketplace, or more generally to further the economic self-interest of the participants. These kinds of boycotts, and it's, you know, a very sharp contrast, they are not protected really by the First Amendment at all. The government has free rein to restrict this kind of anti-competitive collective behavior as much as it can. And there is a middle category. First Amendment law is always complicated. So you cannot just have two categories, you have to have three categories. There's a middle category of boycotts that further economic ends in order to achieve political aims, or vice versa. This is the category we might think of as the labor boycott, where there's both economic self-interest and larger political ideological ends on the table. And in this context, the court has extended protection to some forms of labor boycotts, the primary strike, but not others, the secondary strike. And I think we'll talk about that later on in the conversation. There's a certain kind of ambiguity or uncertainty about what to do about these kinds of boycotts. But with respect to the political boycotts, there is no ambiguity and no uncertainty. The court has recognized that this is one of the forms of collective action that is part of our democratic society, and therefore it is a form of collective expression that is protected by the First Amendment. Now, viewed doctrinally, this is why the BDS movement and the anti-BDS law is very easy, because the movement is quite obviously and quite self-consciously a political boycott intended to promote political change by imposing both, I think, economic and reputational sanctions on both Israeli government institutions and then on private Israeli institutions that are understood to be complicit in the state's abuse of Palestinian human rights. This is an easy case because there isn't this confounding question that is sometimes around of, is there economic self-interest at stake? This is kind of a classic consumer boycott in which the stakes are clearly political and ideological. This means, the consequence doctrinally is that laws that deny those who participate in the BDS movement a right to receive government contracts or sanction them in other ways constitute very straightforward examples of unconstitutional conditions. That is to say, they say to the participant in the movement, you may not receive this good because of your desire to engage in what is a constitutionally protected expressive act here. And therefore are unconstitutional. It doesn't mean that courts are going to necessarily find them unconstitutional, but the doctrine is quite clear. And this is notwithstanding the fact that opponents of the BDS movement claim quite often that its motives are anti-Semitic, or that its effect is to dehumanize or demonize a Jewish people. So for the most part, when we are talking about the First Amendment from a doctrinal perspective, the courts do not care if the expressive activity that the First Amendment protects advances heinous goals or great goals. This is not so much because the First Amendment is value neutral. There's often the claim that the First Amendment is value neutral. It is not value neutral. The First Amendment embeds all kinds of values, including perhaps primarily the value of democracy. But one of the values that goes along with the commitment to the value of democracy over other forms of government is that it is up to members of the political community rather than the government to decide what is or is not heinous political expression. And so the courts are unwilling to make distinctions between forms of collective action that contribute in what we might think of as a normatively desirable way to democratic self-government and those that do not, okay? Now, this is not to say that there are no limits on the forms of collective action and the means and ends that participants in the political community can adopt to achieve political and social and economic change. So, you know, it's interesting to think about boycotts, to think about other forms of coercive collective action that we might think of as intended to achieve economic, political, social change. And for example, the courts have been quite clear that violence, even when it has an ideological end and even when it is motivated by ideological commitments, does not enjoy First Amendment protection. This is outside the scope of the permissible arena of collective action in a democracy. But doctrinally, boycotts are within the scope. This is one of the means by which the court recognizes that members of the political community can make their voice heard. Now, I think this is interesting. And this is true, notwithstanding, as Amy suggested in her introductory remarks, that there are ways in which boycotts threaten or violate certain conceptions of our liberal ideals, which is to say, for one thing, they don't act necessarily through deliberative channels. They affect change not by necessarily persuading their targets of the correctness of their views, but by threatening or imposing economic sanctions. And also because I think one of the reasons that boycotts are such problematic and complicated political devices, although I think very useful and illuminating, is that they tend to sweep quite broadly to include, as in the BDS movement, both those who are directly responsible for the harms that the boycott is seeking to challenge, whatever they may be, and also those who seem to an outside observer perhaps neutral, to use the language of the labor boycotts, which is the institutions and market actors that are perhaps complicit with or not resistant to the challenge practices, but are not them directly responsible for them. And I think that the example of BDS is an excellent example of this. You know, I think one of the reasons why it is perceived as anti-Semitic or dehumanizing by its critics is because it sweeps so broadly to include not only Israeli state institutions that are directly responsible for the policies that are being challenged, but universities, merchants of all kinds, companies, cultural institutions who, in the view of the organizers of the boycott, are complicit, but in the view of its critics are neutral. Okay, so I guess I'll just say two quick things about the sort of what the doctrinal story, which I think is an easy one, tells us. So one is, I'm a First Amendment person. I think about things in terms of what they tell me about the First Amendment. And I do think it reveals something profound and underappreciated about modern First Amendment law, which is that it does not rely upon a deliberative account of democracy. That is to say, the modern First Amendment precedents do not presume that the primary way in which political change occurs in our society, and certainly not the exclusive way in which political change occurs in our society, is through reasoned persuasion. From the early 20th century on, the court has relied upon a much more capacious conception of the kinds of collective and individual expressive acts that are important to democracy, one that includes spectacles, emotional appeals, narrative art, lies, and also the kinds of coercive collective action that are boycotts. Now, I'm sure we'll talk more about the problems with this very expansive or Catholic conception of what's democratically valuable, collective or expressive action. I will say as a first cut that normatively, I think it's very good that at least when we're thinking about the First Amendment, the court has embraced such a non-judgmental and maybe non-Habermasian view of democracy. So for one thing, simply as an empirical matter, as a positive matter, it is obviously the case that democratic politics isn't purely deliberative and involves lots of sort of spectacular, emotional, and also we might think coercive forms of political engagement, both soft and hard. And so if we want to have sort of a realistic account of how democracy works, it seems good to have a more expansive conception of what kinds of collective action are democratically valuable. But also when it comes to the boycott, this approach seems particularly useful because it allows a kind of anti-subordinating politics that a more restrictive, more deliberative account might not allow. This is because one of the great one of the great values or merits of the boycott as a political tool is it allows groups to translate economic power, economic value into political power. And this has proven historically incredibly important for groups whose only social value is their market value. Boycotts threaten liberal ideals in part, and they transgress our notions of who's neutral and who's not, who's complicit and who's independent, because in part they depend upon and reveal our interdependence as members of market society. And they produce and enable forms of power that would not be possible if we relied on a more deliberative conception of what kinds of collective action is possible, if we allowed people to only engage in kinds of reasoned persuasion. So I guess I'll just conclude by saying I think the tension that boycotts obviously create with a deliberative ideal of democratic politics, we might think is a virtue, not a cost of the mechanism. And it is certainly part of the sort of only one of the ways in which modern First Amendment law recognizes a very expansive, very rough and wild democratic society, maybe the democratic society that actually exists. Okay, I'll stop there.
That's wonderful. So now I'll turn things over to Amanda Sheener.
Terrific. Well, welcome everybody. And thank you all so much for coming virtually. It's really a pleasure to be here with all of you in cyberspace out there today, as well as with this illustrious and really wonderful panel of people. So as Amy said, I'm Amanda Sheener and I'm an assistant professor here at Wharton. I wanted to flag one thing, which is previously I worked litigating on a bunch of cases, including, as I'm going to talk about a little bit today. So I'm going to give you just like a possible conflict of interest, the Masterpiece Cake Shop case, which involved a baker who refused to sell a cake to a gay couple. Okay, so with that caveat in mind, in my short opening remarks, I want to touch on three big ideas. First, I want to lay out a little bit more First Amendment history. Genevieve covered a lot of this, but I want to kind of flesh out a little bit more around boycotts and what we might more broadly call economic refusals. Second, I want to outline a key tension that I see within the First Amendment's treatment of economic refusals. And finally, I want to suggest that the best way forward from that tension is for the First Amendment's treatment of economic refusals to be guided by a pretty thick substantive vision of democratic participation, all in the next 7 minutes. Okay, so first a little bit First Amendment history. As Amy said, boycotts and other economic refusals have animated some of the most critical and divisive issues in American history, from the Boston Tea Party to 20th century labor strikes to civil rights boycotts. Organized movements have used boycotts to spur and respond to, oftentimes backlash against, watershed social changes. Today, as we confront deep racial, economic, and political divides, boycotts remain relevant across a diversity of groups, interests, and ideologies. And what I want to do today is to consider boycotts and their constitutional status within the broader context of what I'm going to call economic refusals. So we've seen as you probably know, a rash of recent cases that oppress the rights of businesses to refuse to serve or hire LGBT customers and employees. And perhaps the most prominent case is Masterpiece Cake Shop, which I said is a case involving a bakery's refusal to sell a wedding cake to a gay couple. These cases raise long simmering social and constitutional questions about the rights of businesses to refuse Black, immigrant, female, or other customers and workers. And although we might question whether or not these refusals are really boycotts, right, they press on the very same set of constitutional issues and considerations as traditional boycotts. And I think considering this whole kind of like broader category sheds light on how we should think about them and boycotts in particular. Okay, so my big question, what economic refusals are or should be constitutionally protected in the United States? To consider that question, let me give you a quick whirlwind tour of constitutional history, which I think, to put the bottom line up front, which Genevieve hit on, for many decades, a central organizing principle of First Amendment doctrine has been a distinction between political speech, association, and expression on one side, and then similar types of activities in the economic sphere on the other. And under this rubric, as Genevieve said, the court has protected politically motivated boycotts, but has not given First Amendment protection for economically motivated ones. Okay, but to really understand, I think you need a little bit of context. And with that, first, a surprise, which is, despite the current prominence and cultural magnetism of the First Amendment, and sort of like one of the reasons that we have this, free speech series at the Mitchell Center, the First Amendment's actually pretty young. First Amendment jurisprudence is pretty young, and the protection of speech, association, these types of things in economic life is far younger. So for example, the founding generation thought it was okay to criminalize criticism of government. The Supreme Court didn't address free speech claims until the early 1900s. And even in the 1930s, the court outright rejected the notion that the Constitution protects commercial speech like advertising at all, Advertising, no. Okay, so what is the kind of like deep conceptual architecture of the economic political distinction that's baked into the First Amendment, and also kind of a broader post-World War II constitutional law more generally? I'll point to a couple things. Alexander Meiklejohn, a prominent First Amendment theorist, observed long ago that in a democracy, the governors and the governed are not two distinct groups, but one. He said, "We the people are our own masters and our own subjects." And sort of a related idea of this was crystallized in constitutional law during the New Deal, at a time when American institutions and constitutional law were really radically reshaped in response to the problems and pressures of the first Gilded Age and Great Depression, as well as the realities of the Jim Crow South and the fear of fascism that was made so vivid in World War II. The cases and political discourse of that period suggest that the animating idea of separating the economic on the one hand and the political on the other within constitutional doctrine was to privilege the will of the people in politics over economic power, which is to say, to make the people the governors in politics and the governed in economic life. And on this kind of basic dichotomous view, all boycotts are economic and can be regulable, right? But it wasn't, but this view kind of then began to get problematized. It wasn't until the 1970s, after probably a lot of people on this call were born, that the court extended constitutional protection to speech in commercial life. But again, when it did, it gave more protection to political type speech than to economic type speech. And then the First Amendment, and this is what I want to really focus on, First Amendment doctrine evolved in a really important way on these issues during the Civil Rights era. The cases of that period enriched and problematized this distinction, protecting civil rights boycotts, as Genevieve said, that were political or furthering a political objective, but it refused to protect boycotts that were in furtherance of economic self-interest or an economic objective. Okay, but really importantly, at the same time, it did something maybe contradictory. The court upheld a range of anti-discrimination laws against constitutional challenge when opposition to them came about as a sort of economic refusal of classes of certain sorts of people. So a refusal to serve African Americans, or a refusal of an employer to make a woman partner. So, but even when, and this is the important thing, engaged in for political reasons or for religious reasons or with moral objectives. Okay, so you see that's, so this is the second point, my second point today. This is the main tension that I want to look at. So should the First Amendment protect the right of a civil rights activist to boycott, but not the right of a lunch counter to refuse to serve a Black customer? Under the mid-century model, civil rights boycotters are treated differently because they're understood to be political, while the other is understood to be economic. But surely I want to say this misses the mark, or at least it's really incomplete, because opposition to integration, just like to gay marriage, can be understood as political, even if it takes a sort of an economic coercion type of turn. As a Southerner, I feel like it's obvious that, you know, deciding to serve or not serve a Black customer in the 1960s South has, you know, could be understood as an expressive political act. So what are we to do with this tension? We could, as the current court has, erode this distinction in favor of a very formalistic rights everywhere approach. So basically we could say most things can be understood as political, so let's constitutionalize everything and say the government can't regulate much. Under this view, all boycotts would be protected and all refusals to serve. Okay, and that's sort of like, so Genevieve laid out where the doctrine has been, and what I'm trying to tell you is the Supreme Court has been going in another direction, which just is to say, let's like do a much more expansive First Amendment, and this may be to protect a bunch more boycotts and also refusals to serve. Okay. The problem I want to say with this approach is that it basically, if we really kind of stick with it, means we can't have a government because almost anything can be understood to be expressive or political, you know, like my decision to speed because I like hate speeding laws or whatever, which means that this approach threatens not only to make civil rights laws unconstitutional, but also most government regulation more broadly. Okay, what's more, this approach entrenches existing inequalities and consolidates political and economic influence in the hands of few and undermines meaningful democratic participation. Okay, so that's the problem. And now in my now dwindling time, if that's not the right approach, what is? The Supreme Court has long heralded the First Amendment as the guardian of our democracy. And what I want to say to you is I think the civil rights era, what the civil rights era court did, and what I think the First Amendment should do is to understand that democracy and that democratic participation broadly as protecting and advancing not only meaningful participation in the political sphere or public discourse, but also in fundamental civic institutions like consumer markets and employment life, which in a very concrete way act as a predicate of political, social, and economic power. And on that view, the difference between civil rights boycotts and a refusal to serve customers is that retailers and employers are generally in a different institutional position than customers or employees. And if we were to let those folks actually, generally exclude, this would create a sort of the balkanization of our social and economic life, enclaves of exclusion, and green books rather than the robust participatory pluralism on which our democracy is based. So whereas consumer boycotts, again, generally pose no such threat. Okay, so to wrap up, again, the idea I want to put forward is a broad view of democratic participation, but really it's procedural, but also a positive, normative one, that the First Amendment should advance meaningful democratic participation, not just in political life, but in fundamental civic institutions, including consumer and employment markets, which is a sort of more concrete way of saying that I think most consumer and labor boycotts should be protected, and most boycotts of consumers and of employees should not. Okay, and with that, I'm delighted to hear what else other people have to say.
Excellent. So finally, we'll turn things over to Brian Berkey, who will shed some light on the moral and political philosophical issues around boycotts.
Great. Thanks, Amy. Thanks to the other panelists. This is super interesting so far, so I hope I can kind of keep that going. So like Amy said, I'm a philosopher. I'm not a lawyer, so I come at these issues in a little bit different way. And I'm thinking primarily about how we all as consumers, as actors in the market, should think about when it's acceptable or not acceptable for us to do things like organize and participate in boycotts of firms who have, say, business practices that we find objectionable. So for those of you who saw sort of the earlier advertisements of this event, Wahid Hussein was supposed to be here initially. He's one of the leading thinkers on these issues, wrote a really important paper defending the democratic objection to certain kinds of boycotts. So his view is that the permissibility of boycotts depends on conforming to certain democratic principles, and in particular, the boycotters, on his view, have to aim at bringing about the social change that they want to see through the formal democratic process, specifically the formal legislative process in his terms. So the way to think about what he's getting at is something like this. He's worried that boycotts could be anti-democratic if they amount to a group of people gathering together using their market power alone to generate social change, to, for example, get businesses to stop doing something that they don't want the businesses to be doing, purely through an exercise of economic power, right? So they would be getting change that they want to see in a way that circumvents the democratic process rather than going through the democratic process, despite the fact that these are the sorts of issues that ought to be dealt with democratically and not through the raw exercise of market power, right? Threats and so on, of an economic sort. So on the one hand, I think that there's something right about Wahid's concern that boycotts respect democratic values and democratic procedures and not aim to bring about social change through the raw exercise of market power. Nonetheless, I think that the way that we ought to conceive of democracy and kind of the values associated with democracy can be instantiated in a wider range of cases than Wahid allows. Again, Wahid claims that boycotters, in order to be acting in a way that's consistent with proper respect for democracy, have to aim at bringing about the change that they want to see through the formal legislative process. And this suggests that any, for example, corporate wrongdoing that makes a firm a legitimate target of a boycott has to be such that there's an appropriate legislative response to that wrongdoing that's not already in place and that the boycotters are kind of aiming to bring about, right? So Wahid's thought is, as part of the boycott effort, those who are, say, the spokespeople for the movement should be doing things like offering arguments in the public sphere that aim specifically at kind of defending a certain kind of legislative action to address the issue that's motivating the boycott. So the use of economic power has to be coupled with efforts within the formal democratic process, with the ultimate aim being to achieve the change that they want to see through the democratic process. So the boycott effort, the use of kind of economic incentives, is really just supposed to be a kind of wedge to kind of start the process of bringing about or enhance the prospects for bringing about change through the democratic process. So my worry about this is that it seems to me that there are a wide range of cases in which consumers are correct to object to some business practices that firms might be engaged in, so that a boycott effort to aim to change those practices seems appropriate, but where nonetheless aiming at legislative change would be problematic, right? So there are forms of wrongdoing that firms might be engaged in that nonetheless it would be inappropriate for the state to kind of enact restrictive legislation to prevent. So, think about, for example, certain kinds of advertising that we might find objectionable. So an example I use is kind of firms that employ kind of sexist imagery or something like this in their advertising campaigns. There's good reason to think, maybe on some kind of free speech-based grounds, that it would be objectionable for the government to impose restrictions on companies employing these kinds of ads. It might just be kind of infeasible, as a matter of enforcement to have such a policy. It might be just too complicated or something along these lines also. But nonetheless, it seems to me that a boycott effort here can be justified in cases of this kind. And so the challenge is, for those of us who are concerned about consistency with democratic values, to try to explain why a boycott in a case like this can be justified, even though the aim isn't to kind of run through the formal democratic process, the legislative process, to bring about the social change. So my solution to this is to suggest that views like Hussein's involve an overly narrow conception of what counts as an appropriately democratic process, and an overly narrow conception of the ways in which the democratic processes can appropriately lead to certain kinds of social change. So it seems to me that the exchange of arguments about what kinds of social norms we should endorse and kind of act in accordance with within civil society just should be thought of as part of the democratic process, part of the process by which we aim to achieve a just society. And in some cases, that exchange of ideas, arguments, and so on ought not aim at bringing about any kind of legislative change, right? So there are kind of processes that are appropriately democratic that aren't so formal and aren't so connected to government action and legislative action and so on. Maybe in the interest of time, I'll kind of wrap up there. There's plenty more to talk about, but I'm very curious to hear what all of the rest of you have to say.
Okay, wonderful. So let me just reiterate that the Q&A is open for anyone who would like to post a question. And again, if you're a student in History 133, or again, if you're a student in Poli-Sci 398, please indicate that because we'll be especially interested to see your questions. I'm actually going to begin, though, by posing some questions of the panelists myself. And the first one that I'm going to pose was inspired by comments and thoughts that a bunch of my students had, which effectively go to whether we should think that all speakers or all boycotters are equal. And more specifically, should we protect corporations' rights to boycott to the same extent as we protect individuals? And the question, I think, ties nicely into Amanda and Genevieve's remarks insofar as they recognize the special role that boycotts can play for those who are otherwise politically disempowered. And at the same time, you know, Brian cautions us about the possibility that boycotts will be manipulated or leveraged by those who have tremendous market power, right? So it could be that our thoughts about the moral or legal permissibility of boycotts turn to some extent on whether the boycotter is an individual or a corporation, or whether the boycotter is without great political power, or instead possessed of too much political or too much economic power. So how should we think about boycotts by large for-profit corporations in particular? Should we take them to be more morally troubling than boycotts by individuals? I take it that the law, at least after Citizens United, would deny that there was any constitutional basis upon which to discriminate against corporate speech that takes the form of a boycott. But does the law have it right in this particular case? So should large corporations enjoy the same First Amendment protection to pursue boycotts that individuals enjoy? So you can, any one of you can jump in.
Well, actually, can I just ask a clarifying question? So when you mean boycott by corporations, are you including within that refusals to serve?
Right.
That is?
No, thank you for raising that. So yes, I'm not contemplating the cases that Amanda has in mind that fall on the impermissible side of the line. I'm thinking about corporations that undertake political boycotts. So they have political convictions and they are going to refuse to transact with certain parties for the sake of these political convictions. Yeah, I can say more. That's helpful.
Okay. I'll just say two things in response to that. So one is, I do think just on the distinction between boycott and refusal to serve, and this is a little bit of response to Amanda's comments, which I thought were really interesting. And obviously, whenever we're talking about forms of democratic politics that involve the exercise of economic power, the question about sort of refusal to serve arises. And it is very useful to think about the implications beyond the zone of the boycott. But I just think as a positive historical matter, it is interesting to me that the term boycott has never been, I think, interpreted to include refusal to serve, because there is an implicit assumption, I think, that it's a different matter when you are the shopkeeper and you're refusing to serve than when you're the consumer and you're refusing to buy, that these positions are not parallel. Now, Amanda shaking her head, I'm just, perhaps that view is unraveling. That's totally possible. Although I'm not entirely sure about that. I think there's a lot of discomfort about how to think about the refusal to serve. I think Masterpiece Cake Shop itself, the opinions are indicative of that. The court found on pretty weak free exercise grounds, the result it wanted, but it didn't actually resolve the case on free speech grounds. I think it's really deep uncertainty about how broad or how to think about refusal to serve. Whereas in contrast, I think the law of boycotts, however inconsistent we might think the treatment of labor boycotts, the law of boycott seems pretty simple for the court. It doesn't find this deeply troubling, or not. It has not found it as discombobulating. And so there's maybe in some ways an implicit recognition of the distinction that Amanda is drawing here between the positions of the seller and the positions of the buyer. Okay, so leaving that aside. So then how do we think about corporate boycotts? So I think Amanda and I here are going to disagree, because I think the one thing that Citizens United got right, no, it got nothing right. But the one thing that it didn't get wrong was in continuing to recognize that corporations can be First Amendment speakers. I don't think I don't have a problem with that. As my remarks make clear, I think it's good to have a capacious conception of democracy and democracy subjects. So I don't think there's any real harm in thinking that corporations are entitled to constitutional value if we have a sufficiently sensitive analysis of the First Amendment to take into account the kinds of power imbalances that might occur in corporate speech cases. So I guess my first response is, I think to the extent that we think people have a right to boycott, corporations have a right to boycott. But that seems like a very theoretical or abstract answer to the question, because as a practical matter, I think it's unlikely that we're going to see corporate boycotts. But maybe I'm wrong. Maybe your students had examples in mind. Because I think one of the things that it is important to keep in mind with respect to boycotts is that boycotts are in many respects a weapon of the weak. Maybe not necessarily, maybe I'm being overly, and maybe that's why I have an overly simplistic conception of boycotts. I like anti-subordinating struggles, so I like boycotts, resisting Amanda's turn to say we have to think about the other side of the coin. But the act of boycotting, the act of refusing to participate in market relations, is an act that occurs when you don't have other more direct means of effectuating your political will. And historically, I think we've seen this, that it's groups that have a few other resources at their disposal who turn to the boycott. So I guess I'm just saying, I'm skeptical that corporate boycotts are really ever going to be a problem, because corporations, particularly the kinds of big for-profit corporations that I think your students were thinking of, the kinds of corporations that were sort of conjured by the idea of Citizens United, do not need to have recourse to the boycott to effectuate their political will. The fact of the matter is, in our democratic system, those with a lot of money have a lot of means of achieving power through legislative mechanisms, which is why I get, in response to Brian, I want us to have an expansive conception of democracy, not a narrow conception, because I think that there are really very significant downsides to resting too much on a formalistic legislative view of democracy, in part because it favors certain groups and really disfavors other groups. And so I guess I would say, in theory, sure, corporate boycott should be treated like consumer boycotts, but in practice, I don't think we're likely to see many.
Okay, great. I regret not having included an example, but here's one. So this summer, a bunch of large corporations banded together to decide they were going to withdraw their ads from Facebook because they didn't like the way that Facebook was policing hate speech, or not policing hate speech. But before I say any more, Amanda or Brian, would either of you or both of you want in here?
I'll say just a couple things really quickly. So first, I don't disagree with you, Genevieve, that I think that, corporations should be able to speak in many different contexts. So that I think that the question of sort of the coverage of corporate speakers, I don't feel is not uncomfortable to me. That said, the problem with the modern First Amendment doctrine is it doesn't treat different contexts differently. And that was the point that I wanted to make about not just consumers and sellers and employers and employees, but also if we think about what labor unions do, for example, they operate in a very different way than I think the First Amendment sort of conceives of how they do, in fact, as advancing a lot of core First Amendment values. Okay, so what do I think that for-profit corporations could engage or should or shouldn't engage in boycotts? I don't know the answer to that without more context, right? I think the question that we should ask about economic refusals has to do with what are the institutional effects, right? And are they democracy enhancing or not? That's a different question about who's talking, a corporation or not. And it's a different question about whether or not the message they're advancing is what I'm going to say, sort of like, illiberal or not, right? I think illiberal consumer boycotts are fine, right? So like you could be doing a consumer hateful boycott, but as long as what you're advancing is actually not going to like change whether or not people can participate in really meaningful civic institutions, I think that's okay. Does that make sense? So I'll say the same thing with regard to a corporation. I think it's hard to know. Do I think, so for your example, corporations boycotting Facebook because Facebook didn't do what?
Sorry, Facebook wasn't policing hate speech in the way that it was providing a platform for hate speech.
Yeah, so I'm not worried about Facebook's power to refuse major other corporations. And I think a lot of these things are going to fall in that way, that I think that that's a totally permissible form of boycott, because it doesn't strike me as sort of like threatening the ability of people to participate in meaningful ways in like core democratic institutions, and to do so in ways that are themselves, kind of per Brian's point, in ways that are themselves democratic.
And I guess, can I just add one thing, which is that example, it's a really interesting case, but I feel like it understates the extent to which, and again, with the terminology, the extent to which corporations engage in this behavior always already, but we don't think of it as boycott. So I'm just thinking about, an example from a paper I just wrote. In the early 1930s, the 500 largest radio broadcasters in the United States, they created a trade group, and trade groups set policies for their members. And one of the policies of the trade groups is don't sell advertising to labor unions because they engage in controversial activity. And this is a period when the unions they're trying to take hold of this new democratic medium, which is the radio, to advance their cause, and they're completely shut out of the 500 largest radio broadcast stations. That wasn't conceived or thought of as a boycott. No one thought of it as a boycott. It's just a trade organization making a collective decision. And so, but if we think about your student's example, which great example, it suddenly starts looking like a boycott, but it's never really, I had never thought of it as a boycott before. And so it does suggest there's something interesting about the way in which we're configuring the category, which also leads me to want to be generous in our treatment of it, because when economically powerful actors have so many different ways to influence through their market power the actions of others, but many of those ways we don't consider to be boycotts. And so having a very restrictive conception of what's permissible as a boycott is likely to mean to restrict the ability of some groups to use their market power to advance certain ends, but not the ability of others.
So let me just say one thing about this. So I don't have a settled view on whether the law should treat corporations differently here, but I can imagine an argument for thinking that it should, which is basically runs through a couple of claims. One is just that corporations don't have the same kind of legitimate interest in the kinds of legal protections for speech and for boycott efforts that individuals do, because corporations just don't have morally relevant interests in the first place. But the second is that in practice, and this is a democratic concern, in practice it seems much more likely that corporations will use their legal rights to engage in boycotts in ways that first will involve significant use of market power that no individual possesses, but also the speech that will tend to be associated with a boycott effort is more likely to be aimed at promoting the corporation's own commercial interests rather than advancing democratic deliberation in the way that I argue individuals working together are obligated to do in their boycott efforts. So, it's sort of one thing if a whole bunch of people who are attempting to engage in, open, democratic discussion of contested issues in good faith as part of civil society are exercising their market power as part of that effort. It's another thing if the speech that's associated with a boycott effort is really just aimed at advancing the economic interests of the individuals or the entity speaking. And in the latter kinds of cases, it seems much more plausible to me that certain kinds of legal restrictions might be permissible that wouldn't be permissible in the other kind of case.
Okay, great. So I want to pick up on a thread that's come up, and that is a kind of expansive sense of the permissibility of boycotts, even illiberal boycotts. And I want to press Amanda and Genevieve on whether there might be any limits to that kind of thing. And I know that in Brian's work, and Brian, you can correct me if I'm getting you wrong, but I take it that it's a necessary condition for the moral permissibility of a boycott that the boycott's cause be just, such that at least as a moral matter, the scope of permissible boycotts is narrower, perhaps justifiably so. But again, I want to, see just how absolutist, Genevieve and Amanda, you want to be here. So imagine that a boycott is pursued in a way, and here I'm not thinking about sellers who are excluding customers on the basis of protected characteristics, but a particular boycott stands to undermine the livelihoods of members of protected classes and is pursued precisely for that reason. Still no latitude for First Amendment doctrine to come in and condemn the boycott, or for states to decline to contract with entities that are engaged in these boycotts with an eye to subordinating further protected classes. So thoughts on, whether there ought to be any limits here based on content.
Okay, great question. So I'll say first, so Brian is addressing the moral and ethical and philosophical kind of limits and considerations of boycotts. And I guess I'll say in the main, I agree with you, Brian. The question of what the First Amendment should and can do, I think is a different institutional question. And it's an institutional question that, at least as I path it out, kind of necessarily partakes in a form of proceduralism about democracy, right? And I agree with Genevieve that it's a broad one that encompasses something that's more rough and tumble. And I think that that's probably a good thing as a matter of institutional design, even if it's not ideal. And part of that is because I don't think that as a realistic matter, we're gonna be able to have all of Brian's conditions met in a whole lot of contexts. And we maybe don't want them to when we're actually trying to figure out sort of like the direction of the polity. Okay, so, but that said, the idea that I've sort of tried to put forward is that the First Amendment should protect meaningful participation in a range of different, or at least three key fundamental civic institutions, not just political life in the public sphere, but also these key market institutions, which are really core to being able to build both political and social and economic power, right? Without them, just like Genevieve noted, you can't really participate in the world. Okay, this is of course, there can be hard questions. Like, I actually think Masterpiece Cake Shop guy is hard in some ways, because of course he's trying to say we should have more participation of, certain traditional religious little guys, and you're blocking me out of market spaces. And that's in some ways what your hypothetical is, right? And I think there can be those limiting principles, but in this context, right, if we were to, as an institutional matter, so not as an individual matter, but as an institutional matter, say, okay, we're going to treat sellers the same as consumers, that would mean we're going to have a really balkanized space. Okay, so to your hypothetical, I think it depends on what world we're in. Are we in a world in which, right, like this boycott is actually going to do under all these people or not? Is it really going to like threaten their livelihood and their political power or not? And I think that those are the types of really contingent historical questions that First Amendment doctrine has looked at and increasingly doesn't look at in the way that I think it really should, and consider there's sort of like the endogeneity of both economic and political power to influence each other.
That's great. It's really helpful. Genevieve or Brian, did either of you want to say anything further?
No, I basically agree with everything Amanda said. And I do think that one of the ways to understand the doctrinal distinction between boycotts and refusals to serve is an underlying assumption that the harm produced by refusals to serve is much more likely to be destructive of this kind of inclusive public space that is a precondition for democratic functioning than the harm of the ordinary boycott as we understand it. And so, but that is itself, as Amanda suggests, a historical, potentially contingent historical fact. You could imagine a world in which that is not true. And if that world was not true, then one would want different doctrinal rules. There's nothing intrinsic about refusing to serve or refusing to buy that means that we should necessarily treat the two as differently. I think it's just as a historical and sociological matter, the refusal to serve has been a really huge threat to the sort of egalitarian or inclusive nature of democratic civil society, whereas the opposite perhaps has not been, or has not been at least recognized as such. And so there's a way in which you could think of, I mean, this may not be fair, but you can think of the doctrine as trying to achieve a certain kind of anti-subordinating or including aim, but not doing so by saying on a case-by-case basis, we're going to ask, are your objectives just? Are your objectives anti-subordinating or not subordinating? But looking at the character of the action and thinking as a sort of general sociological matter, is this the kind of action that threatens the basic foundations of our democracy, or is this not? And so treating it in that way. But basically, that's just what Amanda said.
Okay, great. So at this point, I'm going to ask Matt Schaefer, who is our postdoc at the Mitchell Center, to cull from the questions that have been submitted. The Q&A has been active, and I thank all of you. Please continue to post questions, but Matt will be, I think, synthesizing a few of them for our panelists.
Great, thanks so much. Yeah, I want to pull together 3 questions that deal with related aspects of sort of economic expression versus political speech expression, you could say. I think this overlaps to some extent with aspects of the kind of Citizens United thread that's been part of this, but maybe also can help us push this in some other direction. So Francisco Javier asks this. For me, this debate boils down to this question: is my wallet an extension of my vote? Is my dollar a proxy for my vote? And asks about court precedents along those lines, maybe beyond the sort of obvious case of Citizens United. And Francisco also asks, whether in sort of more broadly philosophical terms, how we can think about the difference between a consumer refusing to purchase, to make a purchase from a brand that isn't doing something that they want, versus actively donating to a political campaign of some kind, right? The refusal to offer financial support to one thing, is that different in a meaningful way, legally or philosophically, from actively supporting something else? Ian Lustig asks, sort of more directly, is Citizens United just the price that we pay for this right of the politically powerless to use their economic power to engage in boycotts, right? And I think we've touched on aspects of this, right? If the jurisprudential principles could have more attention to the kinds of forms of power that are at stake, then obviously it wouldn't have to be the price that we pay. But how realistic is that at the level of the articulation of formal legal principles? And finally, an anonymous attendee asks about the possibility that restrictions on corporate exercise of economic power, right, whether those could backfire in this kind of way, right? This person asks, how do limits to corporate boycotts apply to divestment campaigns where popular movements are attempting to harness the economic power of corporations for their chosen cause, right? So for example, in fossil fuel divestment campaigns, we have basically grassroots activists asking corporations to engage in a boycott that they're not currently engaged in. And if we were to sort of push back against, say, Citizens United through a jurisprudential approach that takes fuller account of the distinctive kinds of power that corporations exercise, could this actually undermine the ability of activists to push corporations in more socially responsible ways? So I think these are wide-ranging questions, and I think there's a thread here that has to do with like how we can formulate these principles in ways that don't lead to unintended consequences. But I think people would be interested in sort of following up along any of these lines.
That's excellent. There are definitely a lot of very fruitful threads here, and I will let any of you take it in whatever direction you would like.
Okay, I have some thoughts, but can you correct me if I misunderstand the question, because I'm not, yes, okay, so some thoughts. So one is, I think it's interesting phrasing, is my dollar just an extension of my vote or equivalent to my vote? I think as a practical matter in many contexts, and this is why we see the rise of consumer boycotts or the prevalence of consumer boycotts, your dollar is much more powerful a political good than your vote. We know, and this is in part because of decisions like Citizens United and the sort of deregulation of much of our campaign finance framework, that our political system is very not sensitive to the interests and the views, particularly of those who are less affluent. And so for those who don't have a whole lot of dollars, their votes may not count a lot. And so targeted boycotts or forms of consumer activism can be incredibly powerful, particularly if, as the question suggests, rooted through corporate forms, incredibly politically powerful. And so again, when thinking about both the political, the doctrinal, and our normative views on boycotts, I think it is very important to have a realistic rather than idealistic notion of how democracy in this country operates. Because it is not as if you can say simply, well, you should vote rather than use the brute economic force of the dollar, because often those are not equivalents. And in fact, the dollar is much more powerful and valuable. But I resist the suggestion, and this is where I might be misunderstanding, I resist the suggestion that recognizing the validity of boycott and these forms of economic power in the democracy that actually exists means that we have to conclude that Citizens United was correct in deregulating campaign finance, the law of campaign finance, for two reasons. One, I think Citizens United only exacerbates all the problems, all the problems with our democracy that create the conditions under which we're going to have recourse to, we're going to try and get corporations to do good politics for us. We're going to use market power. I think we're going to see increasing wildcat strikes and labor strikes as a means of going outside the ordinary procedural forms of democracy. And I push back against efforts to say those efforts are bad because they don't take a procedurally legitimate form, because they're a response to the failure of the procedures of democracy that actually exist to be responsive to all the members of society. But Citizens United was, it's nominally a corporate speech case. It is about corporate speech, but its effects extend way beyond corporations. In fact, its primary effects, I think, its deregulatory effects, are on individual campaign finance donations, because what the court did in Citizens United was define the government's interest in enacting campaign finance regulations very narrowly, so that the only thing that the government could be worrying about when it enacts these laws is quid pro quo corruption, the actual, like, I'll give you $500,000 if you switch your vote, or if you build a bridge in my neck of the woods, or whatever it may be, rather than the more amorphous but very, very powerful, and we know pervasive, exercise of influence peddling, where I'll give you $500,000 to your campaign, and then you're just nice to me and my buddies when you are choosing to vote. Citizens United rejects that as a justification for campaign finance regulations, and the result is a world that is in which politics is very not responsive to certain classes in society, and where there is this really very strong incentive to move outside the ordinary procedural mechanisms. And in that world, tactics like boycotts become incredibly important. And so the relationship between Citizens United and the boycott is a complicated one. And we might say having a different result in Citizens United actually alleviates to some degree, although only somewhat, the need to find these alternative forms of political expression.
Okay, so I agree with everything that Genevieve just said, and I want to say it again less eloquently, which is to say that, so I agree, I don't know if I'm going to say that your dollar's worth more than your vote, but I think that it's really important to understand the deep endogeneity of political and economic power in this country, maybe ever, and that the use of boycotts and other economic activities have historically been a way that otherwise politically disenfranchised people can accomplish significant social changes. So you can think about this not just as like the civil rights boycotts, but before I went to law school, I worked with a farmer group that runs boycotts against big fast food companies in order to change supply chain practices, right? So a lot of people who are, you know, undocumented and not able to participate in the political system the same way. Okay, so the upshot of this is that like we have to think about, I think, democracy in a different way as involving both political and economic power. And this is part of what I was trying to say about taking a more institutional view, is that we have to think about what democracy means to have sort of like sort of some power and decisions over things that affect your life. And that's not just a form of political voice, but potentially a form of economic voice and a form of participation in various institutions, which again are predicates and sort of endogenous with political power. Okay, and then with regard to whether or not the, you know, boycotts, then we get Citizens United. I think that's totally not true. I think the problem with Citizens United is that it ignores the fact of the endogeneity of political and economic power. It just doubles down on the ability of folks with way too much economic power to hold all the political power in their tiny, like 3 hands, as opposed to in a more distributed way. Right? And if the court would instead think about democracy as much more, in a much thicker way than it's like very thin libertarian, I think very abstracted from real understandings of how real people live their lives, this is why we get something like Citizens United, as opposed to something that, for example, would give more protections to workers, consumers, a bunch of other people, even under the First Amendment, as opposed to the type of kind of money in politics that we see under a more libertarian view.
Yeah, so I mean, some of the things that Genevieve and Amanda just said make me think that maybe a different way of understanding the way in which it might be appropriate for citizens to kind of think of their economic power as, in some sense, a substitute for their votes or something like that, in very non-ideal conditions where the political system isn't responsive to the interests of the majority of citizens, is that when it seems very unlikely that their efforts within the political process will yield results, and when they're substantively correct in, you know, what they're aiming for, right? What they're aiming for is at least better in terms of justice than what they're fighting against. Efforts to bring about social change within civil society, to, for example, put pressure on companies to change their practices, maybe like how they treat employees or something like that, in ways that don't aim at bringing about legislative change, because, you know, that might just seem like it's kind of a hopeless effort, right? Politicians aren't going to, support the kinds of things that would tend to cut against the interests of the people who are funding their campaigns. But perhaps enough consumers can kind of apply enough pressure on companies to get the companies to move at least somewhat in the direction that justice requires, even if you can't get change at the legislative level. And that seems to me very much appropriate in conditions in which the democratic process is so broken that even kind of, you know, a majority of citizens favoring a certain kind of policy change has no hope of getting that policy change implemented.
So this is really interesting, and I'm going to follow up by, I think, pursuing the other side of the coin of Brian's last comment. So far, much of the defense of boycotts goes to the economic disempowerment and maybe also political disempowerment, because economics and political power are so intertwined, troublingly, in our country. And, you know, it strikes me that that's not the most inspiring defense of boycotts one can offer, right? That we have a really messed up set of laws around campaign finance, and lobbying regulation is way too permissive. And so insofar as, or just because many citizens lack genuine access to the political process. For that reason, we ought to countenance boycotts. And so I'm going to ask you to imagine a world much better than the one that we currently inhabit, a world in which campaign finance is actually much more egalitarian, and there are really strict restrictions on political lobbying, and also there's a much more just distribution of resources across society. In that imagined world, do you think that the First Amendment should be as solicitous of boycotts as some of your remarks tonight have suggested?
That's an interesting question. I'll just take a crack at it. I just want to say two things.
Wait, can I say, before you answer her question, can I say something that is like not on her question, which is to say, I want to give a like more resounding like defense of boycotts, which is to say, it's not because our world is messed up. It's because of the endogeneity of politics and economic life. Boycotts are really important political tools. They have been the Boston Tea Party, et cetera, right? And so it's not that the world is messed up, so we need boycotts. It's that the world is one in which politics and economics are related to each other, not just because our system is currently broken, but in any kind of system. And therefore, boycotts are a type of political tool that we should have some kind of First Amendment protection. Okay, now Genevieve, sorry, you actually.
Oh, no, that's basically, so I was going to say, I resist the idea that the problem with boycotts is the campaign finance. I mean, we've always had a society that is far from ideal, in which political and economic power have been dramatically unevenly distributed, in which groups have been entirely cut out. And so at the most abstract level, I think boycotts are a problem for a kind of liberal theory of democracy, but in part they're also because they are an evidence of the failure of liberal democracy to really account for its own preconditions, which is we have this imagination of a society organized around deliberative processes in which everyone has formally equal rights, but this lovely form of sort of what Marx called political emancipation is founded upon profoundly unequal social reality. And so in that context, boycotts are, as Amanda said, incredibly powerful political weapons. Now, if we were to move to Amy's imagined world in which we don't have significant disenfranchisement or disempowerment, I'll just say, that's a world we've never seen in this country, but we can imagine it. I guess I still don't think it would really change my view, though, because then I get, if economic power is really evenly distributed, so I want more than just the majority can get its way sometimes, as Brian suggested. That's not good enough for me. I want real equality, thick equality, which means not just political equality, but forms of economic and social equality. In that context, I don't quite see what the harms of boycotts are, because the threat about boycott is when we have unequal distributions of power. A small concentrated group can use its economic power in ways that subvert sort of equality norms that we associate with democracy. But if we have a nice egalitarian society, it doesn't seem like boycott. Everyone can boycott. We can just have a proliferation of boycotts. We can boycott the boycotters. Maybe it's going to cause economic problems because nobody's going to be buying anything. But the threat of the participants in the political community being motivated by economic concerns or coercions rather than other incentives doesn't seem to me so strong, because it's going to be coming from all sides, I suppose, would be my first cut.
So I'll say one thing to follow up on this, and what I'll say doesn't necessarily kind of push one way or the other in terms of kind of what the law should be in the kind of imagined society that you described, Amy. But in response to Genevieve's last point, I mean, I do think it would be troubling if, even in a rather just society with kind of equal distribution of resources and so on, boycotts kind of became something of kind of a substitute for democratic deliberation and debate about important issues of justice, right? So if everybody just went around kind of boycotting things they don't like and buying from companies that they do like, and the way that we kind of attempted to kind of resolve political disagreements was largely through the kind of use of market power, even when market power is distributed roughly equally, I think that's something that we would have reason to find troubling from the perspective of the democratic values that we ought to endorse. So I think even in that set of circumstances, boycott efforts should be thought of as at most corollaries or kind of, a wedge to kind of enter into democratic debate about the issues that are motivating the boycotters.
Can I ask why, actually? Can I just quickly respond? Because I just think, one of the things that's so fascinating about thinking about boycott is it illuminates how thick market relations are, how much political, social, sometimes religious meaning there is in our relation, in the ways in which we transact and market with others. So I just think people, they're what they choose to consume and who they choose to transact with has all kinds of meaning. So think about, people not purchasing fur because they think about the the animal rights abuses involved in its production. I don't consume meat. That's a kind of boycott. It's not about a particular producer, but it's a kind of product that I don't want to produce, I don't want to consume for all kinds of reasons. These feel like really important ethical choices that are also at the same time sending all kinds of political messages. They are one of the means by which social change occurs in our society. Lots of people stop consuming fur. It changes our understanding of fur, and that's going to ultimately lead perhaps to different legislative views about how we regulate animals, hopefully. And so that just seems like a really rich, useful mechanism where we have a dialectic relationship rather than just a one-way between the legislative process, which is itself the product of all these forms of cultural and social and economic meaning making. One of the ways we make meaning is through our market decision making. And so I suppose I'm uncomfortable with this idea that, oh, no, democracy really happens through the legislature, not through all these other spaces. I think democracy change, social change happens in all these different institutions. So I'm just curious why, even in the ideal world that Amy set out, you wouldn't want boycotts as sort of a viable means of democratic politics.
Yeah, so I mean, so I think they can be a part of democratic politics, both in a more ideal society and in our actual society. And I don't think that the aim of a boycott effort has to be legislative change. I certainly don't think that. I think what counts as part of the relevant democratic conversation is much broader than that. What I worry about is thinking that it's an appropriate way to bring about social change to just kind of gather together a bunch of people who agree with you, organize to kind of refrain from purchasing certain kinds of products without kind of participating in the public discussion of the relevant issues, kind of making a case for why refusing to buy these products is a justified choice, something that maybe other people should do also. So sometimes people engage in something that we can kind of might call a boycott, where kind of all they're interested in is like expressing their own values or like detaching themselves from causal involvement with, a company that they think is doing something wrong. I mean, there's nothing particularly objectionable about that, but there's a way in which I find it kind of puzzling for people to, on the one hand, care enough about the moral issue to, undertake something like a boycott or refusal to, engage with the firm without caring more broadly about changing the firm's behavior, to making it the case that it stops doing the morally problematic things that the boycotter thinks that the firm is doing. But I think part of the appropriate process for trying to change the firm's behavior has to involve not merely applying economic pressure, but also participating in public discussion and debate, making the case for why we should think that what the firm is doing is objectionable, and hopefully bringing about broader social change if the boycotters are correct that what the firm is doing is wrong.
So I'll say first, in terms of like organized boycotts, mostly people do that, right? Because like otherwise, how are you concretely going to get other people to boycott? But I want to say something that's like similar to what Genevieve said, which is that like, I think part of what's happening is that in real terms, people always already having political, moral, other considerations when they decide to or not to do business in certain types of contexts, right? Like just like, you know, you want to buy something that's green, or you want to be a vegetarian, or you want to do, you know, do things that support climate change or not, or whatever, right? Or that do or do not support this president or not. So I think that that's I think part of what's happened in modern legal conceptions over things like boycotts is that we don't think about the political nature of economic transactions. We think of them as sort of being neutral because the values of markets are neutral efficiency, when in fact that's like never the case. And instead they're thickly political, thickly moral, thickly ethical. And instead we should think about that and not, I guess my fear is about like reifying democracy as like the location of certain sets of institutions. And instead we should think about democracy as like a much broader set of social participations and forms of power, which include in market forms of power. So I don't know. So I guess, do I think deliberation is important to that? I guess I think so, but I'm not so worried about people not discussing, because otherwise how on earth would you get them to do one thing versus another thing if you're trying to organize a boycott in an ideal world or a not ideal world?
Can I say one other thing though? I agree with all that, but I do think that society, I think that the current social reality in which one of the primary means by which people express their political convictions is through their consumption decisions, I think that is indicative of the thickness, as Amanda suggests, the political and social thickness of market relations. I also think it's a sign of political disempowerment and sort of the very bad state of our political realm. So in an ideal world, I would not want primary form of politics to be consumption choices. It's simply insufficient to achieve the aim that you're seeking for. And it's a kind of passivity where you think of yourself primarily as a consuming creature, and the market is the place in which you exercise politics, in part because it doesn't require a lot of coordinated collective action. I mean, I know myself, it's much easier, just think about democratic politics itself, which has largely become consumerist insofar as you want someone to be elected somewhere, you give them some money. It has come to mimic the operations of the market, because these are the sort of easy ways to achieve agency, to feel like you're affecting something. And it seems pretty straightforward. And I feel it, you know, I do, that's the way in which I primarily engage in politics too, but it does feel like an emaciated conception of the kinds of collective action that ideally we'd want in democracy. But again, I don't think that's because the form itself is necessarily bad. I think it's an indictment of the larger political system.
Yeah, again, this is all really, really fascinating. It might be useful at this point to interject or inject a distinction between conscientious consumerism and boycotting. So some of, I think, the power that you're wanting to bestow upon consumers, namely the power to, you know, buy things in ways that feel like they align morally with one's convictions and refrain from buying other things like meat that don't have the potentially troubling aspect of boycotts, because they don't have a threat component built in, right? They're not aimed at changing someone else's conduct. They're just aimed at enacting one's moral convictions in the marketplace. Amanda's already shaking her head. And maybe to give this a little bit more life, you know, I have this very naive conception sometimes of the marketplace. I don't think about big corporations as much as I think about the little seller in the town center who wants to set up shop and who risks not getting customers because people don't like the views that she expressed at the school board meeting. You know, I would have thought that some of the scholarly work on the encroachment of the First Amendment into economic spheres of life, work that seeks to affirm decisions like JC's that see a distinction between the social and the economic would support the idea that this person shouldn't have her business boycotted simply because she expressed unpopular viewpoints at the school board meeting the night before, right? Maybe you don't invite her to your barbecue, but the market is not the place in which to enact your opposition, and certainly not the place in which to pressure her to change her views. And the appropriate form that pressure should take is the deliberative, persuasive form, and not the I'm going to, deny you the opportunity to earn a livelihood form. So thoughts or reactions to that?
I have two thoughts, as always. I seem to always have two thoughts. So the first thought is, I think you are threatening, like when you purchase the veggie burger but not the meat patty, you are communicating to the seller of meat, if there are enough of you, you're going to go out of business unless you change your production process. And if you band collectively together, as vegetarians often do, and you try and disseminate this ideology to others and say, and shame them, as when I was in high school, I would shame my parents when they'd buy meat, for all kinds of reasons. I'd show them lots of pictures of nice, happy little cows. There is an implicit threat. The market works through threats pervasively. So I'm not sure I would make that distinction between a boycott and conscientious consumerism. That said, we might think that there's a difference between a threat that is somehow related to the product itself. Somehow it has to do with what the seller is selling, because that's the kind of market incentives that we think power the free market society, and something that is independent of that. So Amy, your example of the shop owner who makes remarks that have nothing to do with her business and then is penalized for it, that actually does feel distinct to me. And so it raises a question, and this is a question I think that is difficult in the First Amendment sphere, which is, what do we do with viewpoint discrimination, content discrimination that is private? So the sort of rough and ready view is that what the First Amendment, and I think this is really problematic, but this is the conception of what the First Amendment is doing, is that it's prohibiting the government from engaging in viewpoint discrimination, from penalizing people for their views and imposing disabilities on them, which is why these anti-Bds laws are wrong doctrinally, but in order to empower private people to be able to do that with each other, because it's through viewpoint discrimination, it's through not liking someone for their views or not associating with them or maybe not purchasing from them, that the marketplace of ideas functions. That discrimination is a crucial mechanism through which change occurs, and one of the mechanisms through which it occurs is you have views that people don't like and they sanction you for it in whatever ways they sanction you for it. Now, so one might think that that example, poor her, but that's how the marketplace of ideas works. Now you can imagine, you can see that that has all kinds of downsides. We think of it as like a beautiful operation that gets us to truth, but in fact, what we're seeing is forms of shaming and sanctioning and pressuring people to adopt the views that they have or to shut up about views. There's plenty of censorship, of threats, of all these kinds of unpleasant things implicit in that. And so I feel for that shopkeeper in that hypo, but it is not obvious to me, and so it's an absolutely imperfect situation, but it's not obvious to me that any alternative would be better, that empowering the government to be able to restrict people from engaging in viewpoint discrimination in certain ways, or identifying, valorizing certain spaces as outside the space of politics, like the market, that seems to me really problematic for all the reasons that I guess Amanda and I were talking about.
Yeah, so I agree. I think that the first thing that I want to say, though, is I think that your kind of like division between sort of conscientious consumerism and boycotts may be different in terms of how much people are actually thinking of themselves as passive consumers, right, and the marketplace as a neutral space, versus how much they understand, as boycotters do, that, you know, this is the space in which important issues are fought out, in which we decide the direction of our society. And I'll say that boycotts being organized, and you worry about them being coercive, but they have that feature of recognizing the sort of like values of the market, right, and their relationship to other important institutions. Whereas passive consumerism really is, I think, does show the way in which this idea that market spaces are you know, are neutral and efficient has kind of won, where the only thing I can do is like decide whether or not I'm going to like, you know, buy beef jerky or buy a veggie burger. And I think that that's a problem, whereas boycotting strikes me as less of a problem. I agree with Genevieve that part of the thing that we do, and I guess I am worried about your shopkeeper, but I guess I'm as worried about kind of like the marketplace is always coercive. It's like the way that the marketplace is coercive is so much more pervasive than like the boycotter and that shopkeeper, right? Think about the way that marketplaces just like trash through communities, right? By paying them not enough, trash through communities of color, right? It's like the ways that marketplaces are coercive is so much more powerful than like the ways that, of course, we make decisions every day. Like I go to a place because like the barista is like nice to me, right? Is that coercive? Maybe, because I don't go to this other barista's place. I don't necessarily have to go to the like woman who said nasty things at the you know, meeting, at the PTA meeting last night. I don't know if that's more or less coercive. It's maybe more personal, and so we feel it as kind of like having a thicker moral valence. But I think that's because we occlude these kind of like far more coercive economic mechanisms from being within a moral space. And I think that's the problem more than the other thing.
So we're basically out of time. Brian, if you wanted to get the last word, it's yours.
No, that's okay. Thank you, though.
Well, let me thank all three of you. This has been a wonderful conversation, and it's such a pleasure for me to get to raise ideas that have been percolating in my mind, and to, yes, just be able to engage. Thank you to all of our attendees. Please stay tuned for other Andrea Mitchell Center programming, especially as it relates to the Free Speech Battle series. And again, tremendous thanks to Genevieve, Amanda, and Brian.
Thank you all. This was such a pleasure.
Yes, great. Thanks, everyone.
Bye. Good night. Thank you. It was great.